When you watch this video, you have to ask yourself one question. Is it cunning or cowardice? Here's what we're talking about today. This happened in the courtroom early this morning.
Day, the defense raised with me what I have listed as 5 separate issues that it wanted to alert the court to with regard to the expected testimony of Mr. Walsh today. As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not? All right. Does that moot every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right.
As Gomer Pyle used to say, surprise, 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 because this was clearly not what the judge thought was coming. She thought he was going to testify. And I'm sure she had all of the documentation and all of the case law ready to go in the event that there were issues related to his testimony. After putting on a case that generally attacked the prosecution and making reference in his opening statement to what Brian would tell about what happened on the night that Anna Walsh died, we find that Brian is not going to testify and that there won't be any other witnesses either. And that probably makes good sense because there's no reason to have an expert come in and talk about sudden death syndrome or sudden unexpected death when the person who is going to set the stage for that evidence is not going to testify at all. It is amazing to me that this happened, but it also there could be a couple of motivations for it. The one motivation that comes immediately to mind is the issue of cowardice. Brian Walsh knew that the story that he told to his lawyer about finding her suddenly deceased, and then instead of calling 911 to, do the things that he did, I think he realized how completely unbelievable that story was, and he did not want to face cross-examination. And as a result, he withdrew from the idea of testifying. So we know that he's not a nice guy, but now he's also a coward when it comes to actually having to stand up and put forth what actually happened on that night. And I think he knew he would get questions like, why didn't you call 911? Did you check for a pulse? Is the reason you didn't check for a pulse because you knew you had already killed her? All of these things are going to come up in cross-examination, and he's going to look like a moron. Not that he looks like a Rhodes Scholar anyway, but at the bottom line is he knew he couldn't withstand cross-examination, and so he said, no, I'm just not even going to do that. Which means, I think, in some respects, that he knew early on that there was no way out of this, and that it was better to go down without testifying and hurting himself further than it was to go forward and perhaps dig his grave even deeper. Now, this next motivation, I'm going to say, I want you to understand I have no knowledge of what kind of lawyer Larry Tipton is. Like I said, I've been pretty surprised at how effective he was on cross-examination of some of the state's witnesses, and the fact that he didn't cross-examine all of those needless DNA experts that they put up. So with that understanding, I'm not criticizing or accusing Larry Tipton or the other person who's representing Mr. Walsh of any malfeasance here. But if you think about it, they really have, in some way, the perfect setup. Brian Walsh now doesn't have to face cross-examination, and they've already gotten in on their initial opening statement this theory of sudden death. And keep in mind that the judge is going to remind the jurors that nothing that the defense counsel said or that the prosecutor said was evidence. I get that. But it's already been in their brain, and it's been in their brain for the entire trial. So how do you get it out of their brain? How do you not let them deliberate on it? The fact is, they are probably going to consider it in their deliberations, even though it's not evidence. It's like telling somebody that, you don't want them to think about a giant pink elephant in a green tutu sitting on a stool in the corner. If you tell somebody not to think about that, immediately in your mind, you've got this pink elephant with a green tutu sitting on a stool in the corner. It has the effect of, in some ways, almost increasing the value of having gotten that in during opening statement, even though it's not evidence. And even though the evidence that he asserted would be produced was not produced. The jury doesn't have a body to look at. It doesn't have autopsy photos. It doesn't have anything to suggest what may have happened to Anna Walsh. And you can't make up for that with a bunch of DNA analysts and crime scene analysts talking about blood that it was found in different places in the house. I think that they now have the opportunity to come in closing argument and just attack the state's case relentlessly. They told you that they had to prove premeditation. And to prove premeditation, they have to show that before Anna was killed, if she was indeed killed at all, before anything happened to her, that he had consciously thought about doing this, and that it wasn't something like a matter of heat in the moment. But have they done that? No. They've shown you a lot of evidence after the fact. It's important to realize that when he searched for how to dismember a body, for example, it happened well after Anna was dead. And here's the timeline associated with all of those issues. 4:55 a.m., January 1. How long before a body starts to smell? 9:35 a.m., 11:50 a.m., 12:10 p.m. What does bleach do to dead bodies? All of these things occurred after Anna was already dead. And so none of these go to premeditation unless you're talking about premeditating the cleanup. And again, it don't go to premeditating the murder, because by the time you're looking to know how long a dead body smells, the body is already there in its physical form, and you are trying to dispose of it, even as ridiculous and sick as that sounds. So that doesn't go to premeditation. It goes to how do you hide the body, but it doesn't go to premeditation. It may be indicative of ill intent, right? That he planned to get rid of her corpse, but it doesn't show that he planned to murder her. It shows that he planned to clean up after she died. So, in some respects, it's really a win-win for the defense here, and it's a win-lose for the prosecution. Prosecution doesn't get to cross-examining him, and they're really forbidden from criticizing him for not testifying, because he has an absolute right not to testify at his own trial. Now, before she could accept the idea that he was not going to testify or that he'd made his decision, the judge had to run him through a colloquy. Let's listen to a little of that.
So now, I do want to conduct the colloquy with the defendant at this point. Would you like him sworn, Your Honor? Hold on a second, because I'm not sure I have my colloquy with me on the bench, despite the fact that I have quite a few binders here. I think the one I need is in my office, so stay tuned. Nobody move. Clerk. Thank you, Judge.
Mr. Walsh, if you could stand and raise your right hand, please. Do you solemnly swear or affirm the testimony you shall give in the cause now in hearing shall be the truth, and that you shall give all true answers to all questions as put to you by the court in the cause now in hearing? So help you God.
I do.
Thank you.
Excuse me.
You can be seated. I just didn't, was wondering if you were asking me if I wanted him over on the witness stand. I do not. Mr. Walsh, one important decision that all defendants in every criminal trial need to make is whether or not they're going to testify in a particular case. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you are not required to take your attorney's advice. I'm sure that your attorneys, Attorney Tipton and Attorney Porges, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is, the right to ask you questions. If you do not testify, and you and your attorney request me to do so, during my final instructions to the jury in the law on this case tomorrow, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. First, I'm going to ask you some preliminary questions. Sir, in the last 24 hours, have you had any alcohol or alcoholic beverages?
No, I have not.
In the last 24 hours, have you taken any prescription medicines?
I have not.
In the last 24 hours, have you consumed any legal or illegal substances?
I have not.
Is your mind clear here today?
It is.
Tell me in your own words, what are we discussing,
Whether I'll testify or not in my trial.
right? Have you discussed with your attorneys the decision about whether or not to testify in this trial?
I have.
And have you had enough time to discuss your decision with your attorneys?
Yes, I have.
Have your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, they have.
And do you understand what your attorneys explained to you about your right to testify?
Yes.
Has anyone threatened you or promised you anything to get you to give up your right to testify on your own behalf?
No.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Does any party wish me to ask any further questions before I make my findings?
No, Your Honor.
No, Your Honor. I find that the defendant, Brian Walsh, freely, voluntarily, knowingly, and intelligently has waived his right to testify at this criminal trial, and that he's done so with the knowledge of its consequences. I accept his decision.
That was an excellent colloquy, and she conducted it, I thought, in a very appropriate manner and reached the appropriate result, I think, by determining that, yeah, he did knowingly and intelligently, well, I don't know about intelligently, but knowingly understand the consequences of what he was doing. So the question remains, was it cunning or cowardice? I don't think it was cunning, at least not on Brian Walsh's part. He's quite the con man, but I don't see him being able to put together this kind of strategy. And given the fact that Larry Tipton has played this pretty straight and not gone in what I would call improper directions or taking improper shots at the other side, I just don't see any evidence of it being a cunning. I think really what happened is he surprised his own attorney. So the issue now is how do they put together their closing arguments? And I'll have a little more on that maybe in another video.
Thanks for watching. I appreciate you being here today. If you have the opportunity today, try to do one kind thing to help somebody else. Any kind thing will do. Buy somebody a Coke, get them a cup of coffee. Anything that makes their day better, that would be a way to help make the world a better place. Because after all, isn't that what we're all after? Now, YouTube has a few things that they think you might be interested in, and they're going to be showing you that right up there.